पंजाब बार कौंसिल मियाँ वाली मलिक सलीम इकबाल साहब, शुक्रिया आपकी भी आमद का। पिंडी गेट से हमारे भाई शेख साहब तशरीफ लाए हुए हैं, उनका बहुत बहुत शुक्रिया। और सबसे बढ़कर ये कि इस मिर्ज़ा अनवर बेग अकेडमी की बुनियाद रखने वाले, जिन्होंने अपने उस पूरे साल में कंटिन्यूसली मेहनत करके उन्होंने बहुत ज़्यादा इसके ऊपर वर्किंग की, और फिर अल्लाह तबारक ताला की ज़ात की तरफ से करम हुआ। आप सारे एडवोकेट्स की ताकत जो कि उनके साथ मौजूद थी, जिस पर उन्होंने कॉन्स्टिट्यूशन में अमेंडमेंट करवा के आर्टिकल 18 की सूरत में मिर्ज़ा अनवर बेग साहब को एक कॉन्स्टिट्यूशनल स्टेटस भी दिया। मेरी मुराद हमारे प्रेसिडेंट माशाल्लाह जनाब तनवीर इकबाल साहब, मैं हमेशा हमारे सेक्रेटरी साहब इनको हमेशा कहते हैं सीनियर प्रेसिडेंट, क्योंकि हमसे पहले और हमारी कमेटी के अदरवाइज के हमारी एग्जीक्यूटिव बॉडी के ये भी मेंबर हैं, और इससे पहले जो सेकंड थे तलत महमूद जैदी साहब, इनसे पहले, क्योंकि ये दो अहबाब जो प्रेसिडेंट प्रीवियस होते हैं वो आपकी एग्जीक्यूटिव बॉडी के एक्स ऑफिशियो मेंबर होते हैं। इस हवाले से ये हैं, इनको भी मैं खुश आमदीद कहूँगा। यहाँ पर आज बहुत सारे ऐसे चेहरे मौजूद हैं कि जिन्होंने गाहे बगाहे जब भी किसी लेजेंड का अगर लेक्चर हुआ तो ज़रूर आते हैं। मैं पिछले 2 दिन मेरी एडिशनल सेक्रेटरी साहबा सुमेरा साहबा नहीं थी, अल्लाह ताला उनको से तंदुरुस्ती अता फरमाए, आज वो मौजूद है। बाकी मेरे जो एग्जीक्यूटिव बॉडी के मेंबर लाइब्रेरी सेक्रेटरी साहब मौजूद हैं, आज वो भी मौजूद है यहाँ पे। वैसे कोऑर्डिनेशन के हवाले से यासिर साहब, सुमेरा और इस्मा, ये तीनों चूँकि सारे कोऑर्डिनेट भी करते हैं, इनकी मौजूदगी यहाँ पे बड़ी ज़रूरी होती है। आज यहाँ पे देखकर खुशी हो रही है। मैं आपके सामने जिस शख्सियत बुलाने लगा हूँ वो किसी तारुफ की मोहताज नहीं। अगर मैं ये कहूँ कि क्रिमिनल साइड के ऊपर, स्पेशली मर्डर ट्रायल के ऊपर इस वक्त अगर रावलपिंडी में कोई बेस्ट चॉइस है, या रावलपिंडी में अगर मैं ये कहूँ कि एक ऐसा शख्स जो ट्रायल को सिर्फ इस पर्पस के लिए नहीं करता कि उसने अपने पार्टी को, अपने क्लाइंट को रिलीफ लेके देना है, बल्कि वो इसलिए करता है कि उसने एक अच्छी जजमेंट जज से करवानी है, और बहुत ही हर मर्डर के ऊपर, चाहे खुद या अपने अपोनेंट कौंसल या जज साहब हो, उनको प्रॉपरली असिस्ट करते हैं और उनको बताते हैं कि ये चीज़ ऐसे नहीं ऐसी होगी। तो वो सिर्फ और सिर्फ एक ही नाम है इस वक्त, जिसको मैं अंसर नवाज मिर्जा के नाम से जानता हूँ। इनके वालिद ग्रामी जहलम के बहुत बड़े वकील, इनके सीनियर जिनको मैं दादा उस्ताद कहा करता होता हूँ, सरदार मोहम्मद इसहाक खान साहब, क्रिमिनल में कोई शक नहीं कि उनका कोई सानी नहीं था, और उन्होंने अपने बहुत सारे जानशीन छोड़े हैं। लेकिन दर हकीकत अगर ये कहा जाए अगर वलिया किसी को बनाया तो यही है जो अंसर नवाज मिर्जा है, और बेशक कोई शक नहीं, इंतहा दर्जे के खूबसूरत ट्रायल के वकील हैं। आप में से बहुत सारे साथियों ने तलत महमूद जैदी साहब जिस वक्त प्रेसिडेंट थे तो उनकी बैठक में इनको सुना होगा, जिस वक्त इन्होंने मर्डर रेफरेंस के हवाले से उस वक्त यहाँ पे सारों को बताया था। क्रिमिनल साइड के ऊपर कौन सी चीज़ें ज़रूरी हैं, ट्रायल कैसे ज़रूरी है, और उसको एविडेंस को किस तरह लीड करना है, आज इनके पास कोई टॉपिक है। और क्रिमिनल साइड के ऊपर जो भी हमारे साथी दिलचस्पी रखते हैं, मैं समझता हूँ कि उनके लिए आज का ये लेक्चर शायद आपकी 10 साल की वो मेहनत जो पहले आपने की है मुस्तकबिल में करते, वो शायद आपको सारा कुछ ना देती कि जो आज अंसर नवाज मिर्जा साहब आपको इस 1 से 1.5 घंटे के अंदर देंगे। मैं आपके और इनके दरमियान ज़्यादा देर हायल नहीं होना चाहता। मैं रिक्वेस्ट करूंगा हमारे आज के मेहमान खुसूसी, और आज वैसे हमारे उस्तादों में से हैं क्योंकि हम पूछते रहते हैं, और आज सीखने के बाद हमारे उस्ताद भी अब होंगे जनाब अंसर नवाज मिर्जा साहब। तशरीफ लाइए, क्लैपिंग करेंगे आप प्लीज।
बहुत शुक्रिया सदर। सबसे पहले जो मिर्जा बेग लॉ अकेडमी ने जो एक सिलसिला शुरू किया है, यंग लॉयर्स की लर्निंग की एक अपॉर्चुनिटी क्रिएट की है, उसके लिए वो मुबारकबाद के मुस्तहिक हैं। तो तनवीर इकबाल खान साहब ने इसमें बहुत अहम रोल अदा किया, शेख अलियास साहब और हमारे दूसरे सीनियर्स ने, और उसके बाद जो हमारी मौजूदा बॉडी है उन्होंने इस अमल को जारी रखा। तो मैं इन सबका शुक्रगुजार हूँ कि उन्होंने आज मुझे मौका दिया कि मैं अपने व्यूज़ शेयर कर सकूँ आप लोगों के साथ ऑन द टॉपिक ऑफ क्रिमिनल ट्रायल। एक चीज ध्यान में रखिएगा कि जो आज की डिस्कशन है, इट इज नॉट विद रिस्पेक्ट टू एनी educational point of view, rather it is a conceptual discussion. It will be aimed at to make you understand what is the meaning and purpose of trial, what is the concept of trial, and how it is to be conducted. First of all, trial means proceedings in which the court determines the guilt or otherwise of an accused who is charged with an offence. It starts with a presumption, and presumption is of innocence of the accused and a burden which is placed upon the prosecution to prove the guilt of the accused as is required in the adversarial system of criminal justice. There are basically two kinds of trials which are carried out in our criminal courts. One is known as the magisterial trial and the other is the sessions trial or trial before the High Court. Procedure is almost similar with minor differences between the two. There is a stage, there are proceedings which are conducted prior to the commencement of the trial. They are also equally important to understand for the reasons trial commences after the submission of report under section 173 CRPC. Before that, there are numerous steps which are taken for the conclusion of that report. At the first instance, FIR is registered in a criminal case. FIR, you all understand. I will not discussing those areas in details because that is a separate chapter and we will discuss it someday later. After the registration of the FIR, investigation is carried out by the investigating officer, which includes the recording the statement of the witnesses, spot inspection, arrest of the accused, remand of the accused, and other proceedings are carried out, and a report under section 173 CRPC is prepared and submitted before the magistrate. Now the magistrate, after the submission of report under section 173 CRPC, he peruses that and he determines the jurisdiction and the cognizance at the first instance. He will determine at the first instance whether this case is triable by the magistrate himself or it is to be tried by the Court of Sessions. How he will determine it, it is mentioned in the second schedule of the Code of Criminal Procedure 1898. There is a schedule in which it is mentioned that which offence is triable by which court. You will find certain offences triable by Sessions Court, but still the magistrate tries them. For that purpose, you have to understand the meaning of section 30. All those offences which are triable by the Court of Sessions, but sentence is other than the death, they are to be tried by the magistrate section 30. And once the court determines under section 190 that the case is triable by the magistrate himself, he will take the cognizance and proceed with the trial. But if he comes to the conclusion that this case is exclusively triable by this Court of Sessions, then he will send that report under section 173 CRPC to the Court of Sessions. Because under section 193 CRPC, Sessions Court cannot take direct cognizance. It can only take cognizance once it is sent up to it by the magistrate. Prior to this practice or procedure, there was a time when there used to be commitment proceedings. In all the cases triable by the magistrate were first tried by the Sessions Court, were first tried by the magistrate. And after recording the entire evidence, if the magistrate comes to the conclusion that there is evidence available and the accused is to be tried by the court of session, then he used to commit those proceedings to the court of sessions. That was abolished in the year 1974-75, and this procedure was adopted and passed through the bill. There are special courts as well. Special courts includes anti-corruption court, there is special judge central, there is anti-terrorism court, and the court of for the control of narcotic substance act. ANF court is they also tries the case as a sessions trial, except the court of the anti-corruption. Anti-corruption court and the court of special judge central tries the case on the basis of Criminal Law Amendment Act 1958, and Section 6 perhaps states that the trial will be a magisterial trial before the court of the anti-corruption and the special judge central. They have been invested powers of the magistrate as well. The court of anti-terrorism also possesses the same power. They do not require the challan to be sent up to them by the court of the magistrate. They can take direct cognizance. Even the anti-terrorism court can take direct cognizance of any report submitted to it under section 173 CRPC. So these are different courts, and the manner in which they take cognizance. But those are special courts. So far as procedure in the general, under the general law, the Court of Sessions take cognizance on the submission of a report to it sent up by the magistrate. The procedure for the magisterial trial we will discuss first. Procedure for the magisterial trial is mentioned in chapter 20 of the Code of Criminal Procedure. At the first instance, once the magistrate has decided that it is exclusively tribal by itself, then he will, at the first instance, supply the documents to the accused free of cost, as required under section 241A of the CRPC. And those documents includes these statements recorded under section 161 CRPC, the statements recorded under section 164 CRPC, and the first inspection note, which is prepared by the investigating officer at the time of his first visit to the spot. And these documents are to be supplied at least, rather word have been used, not less than 7 days before the commencement of the trial. कम से कम 7 दिन देने हैं ताकि एक्यूज उनकी बेसिस पे अपना डिफेंस जो है वो प्रिपेयर कर सके. सेशंस ट्रायल में भी प्रोसीजर सेम है. थोड़ा सा डिफरेंस ये है कि इन अंडर सेक्शन 265C the documents which are to be supplied includes the FIR, the report under section 173 CRPC, statements, all the statements recorded under section 161, 164 CRPC, and the first inspection note. They are to be supplied within 7 days of the commencement of trial, not later than 7 days. So this is a minor difference but the content, intent and purpose is the same in both the trials. That the accused should be supplied the copies of those documents, including the statement of the witnesses which are going to appear him at the time of trial against him, and he should have the knowledge before the commencement of the trial about their deposition, and he should prepare his case accordingly. Then once the documents have been delivered, and under section 241A CRPC in a magisterial trial, after 7 days the case will be fixed for the framing of charge under section 242 CRPC. How charge is to be framed, that is mentioned in chapter 19 of the Code of Criminal Procedure under section 221 CRPC. That it will state the manner, date, time and place of the occurrence, the offence with which the accused is charged. These details are to be mentioned, and which court is trying the accused. These facts are to be mentioned by the court in the charge as required under section 221 CRPC. The magistrate, here there is another difference under section 265D in the Sessions Court. Under the procedure, the court has to peruse the record and form an opinion that there are sufficient grounds to proceed with the trial, and then he will frame the charge. Here that procedure is not mentioned, but practically the same procedure is adopted. The magistrate will look into the entire file, the allegation mentioned in the FIR, the supporting evidence, the statement of the witnesses, and suppose he comes to the conclusion that on the basis of these evidences which are to be led at the trial by the prosecution, there is no evidence, the accused cannot be tried, then the magistrate will resort to section 249A CRPC and will acquit him before the framing of charge. But if he finds that there is material available prima facie on the basis of which the accused can be tried, then he will frame the charge and summon the prosecution evidence. In section 244 CRPC of the magisterial trial, the word which has been used is that he will hear the complainant and take all evidence available and which is produced by the complainant party or the prosecution, and thereafter the court will record the statement after the closure of the prosecution evidence. The court will record the statement of accused under section 342 CRPC. What is 342 CRPC? 342 statement of section 342 CRPC is the statement of the accused recorded by the court, although it is mentioned in 342 CRPC that at any stage it can be recorded, but in the same section it is mentioned that generally it is recorded after the recording of the prosecution evidence. And what is asked in 342? The entire incriminating evidence. आज का वैसे रिवाज ये थोड़ा सा हट गया है कि 342 में वो पूरी जो एविडेंस PW1 से लेके आखिरी तक आती है, PW10 तक 12 तक, वो सारे के एग्जामिनेशन इन चीफ जो है वो रिप्रोड्यूस करके क्वेश्चन पूछ लिया जाता है, लेकिन स्पिरिट ऑफ लॉ ये नहीं है. स्पिरिट इज दैट व्हाट क्वेश्चंस आर टू बी आस्क्ड व्हिच इंक्रिमिनेट द एक्यूज्ड. So enable him to answer all those incriminating material appearing in the prosecution case. And he is asked whether he will produce the defense evidence. He will lead the evidence. Lead means that he will either appear himself in the court and make a statement on oath in disproof of the charges alleged against him in the prosecution evidence, or if he wants to produce, make a statement in his defense. Otherwise, that opportunity is also granted to him. And if he accept or says yes to that question and lead the evidence and or produce witnesses in his support, supposingly, इसके एग्जाम्पल आप ये ले सकते हैं कि एक एक्यूज जो है वो प्ली ऑफ एलिबाई लेता है ड्यूरिंग ट्रायल. I was not present at the time of occurrence, at the place of occurrence. During investigation, उसने ये plea ली. And in support of his claim, he has produced certain documents that I was present in such and such hospital at such and such time. So he can make a statement on oath. He can get someone the record of that hospital, the record keeper, the doctor who has examined him, who has treated him, he can be summoned, and other witnesses in support of his plea. And after recording of statement section 342 CRPC, the most important question which is asked is why this case against you and why the PWs have deposed against you. Whenever you prepare your trial, especially for the defense side, this is the first question which should come into your mind. And you should make a proper defense, proper reply to this witness. What would be the reply? Witnesses are related intercede. They are inimical witnesses to her. They have enmity with me. They are Jaws witness. They were not present at the spot. They are false witness. They have been convicted for perjury previously. All these questions should be in your mind, and you should apply those which are available to the case in hand which you are dealing with. And why this case against you? Kyun case banaya? You can say that I contested such and such election against such and such person. So that was the reason that this case was falsely concocted against me. So this is the first question which you have to make answer of which at the time when you prepare your trial. The foremost question, always keep in mind, कि इसके बगैर आपने अपना केस तैयार नहीं कर सकते. ये नहीं हो सकता कि आप सारे ट्रायल को कंक्लूड कर लें, अपनी सारी क्रॉस एग्जामिनेशन कर लें और उसके बाद आप सोचें जी ये इसका क्या जवाब देना है. इसका जवाब आपने पहले दिन तैयार करना है. पर जब आपने ये जवाब तैयार कर लेना है, उसकी रोशनी में तो आपने क्रॉस एग्जामिनेशन करनी है, उसी लाइंस पे आपने क्रॉस एग्जामिन करना है और वो चीज़ें रिकॉर्ड पे लेके आनी है जो कल को आपकी प्ली को सपोर्ट कर सके. So after recording the statement of section 342 CRPC and the defense evidence if any, what the court will do, they will hear both the sides, arguments of both the sides, and then give a finding under section 245 CRPC, either of acquittal or of conviction. If after going through the record, the evidence, the other record, material available, the court comes to the conclusion that the prosecution has not been able to prove its case beyond the reasonable doubt. वो हम भी शुरू में ना इस गलतफहमी में कहीं शिकार रहे कि beyond the shadow of any doubt word use करते रहे. That is not the proper word. The proper word is beyond the reasonable doubt. The duty of the defense lawyer is to create doubts in the prosecution evidence. Duty of the prosecutor or the prosecution lawyer for the prosecution is to produce all the evidence which is admissible and which connects the accused with the commission of the offense, and no link should be broken. Whatever the evidence available, that should be produced before the court so that at the end of the trial, he is able to bring home the charge against the accused. And under section 245, subsection 2, if the court comes to the conclusion that prosecution has been able to prove its case, then he will record a guilty verdict. The legal word for the proving of guilt is conviction. आप जजमेंट सारी पढ़ते हैं, कन्विक्शन की जब आप जजमेंट पढ़ते हैं तो इन लास्ट पे क्या लिखा जाता है? The prosecution has been able to prove his case, the guilt of the accused, and he is convicted under section so and so. Guilt prove हो गया, conviction हो गई, then sentence will follow. And he is sentenced to such and such imprisonment, fine, whatever the sentence the court thinks fit or appropriate, that is awarded in a magisterial trial. There are other provisions, 247, absence of complainant. If there is a private complaint and the complainant is not available and he does not attend the court, the magistrate can acquit the accused. But there is a proviso to it. There are two provisos to it. Number one, if the complainant is a public servant and has lodged the complaint in the discharge of his official duties, or his attendance has been exempted by the court. Second proviso is if the offence is cognizable or non-communicable, even then the absence of complainant under section 247 crpc would not result into an acquittal judgment automatically. So section 247 deals with the presence of the complainant. Similarly, 248 is the withdrawal of the complaint. That deals with the withdrawal of the complaint. At any stage, it is permissible. The court can allow the complainant to withdraw its case against the accused if he satisfies that there are reasonable grounds for doing so. The magistrate will allow him. These are the procedural things which are not in practice too much, but section 248 is there, क्योंकि अक्सर आपने देखा होगा कि ट्रायल कंक्लूड होने वाला है तो कॉम्प्रोमाइज हो गया है, तो उस स्टेज पे भी कोर्ट उसको अगर समझती है कि ये दुरुस्त बात है, ये सही बात है और उसको इजाज़त दे देनी चाहिए कि वो अपनी कंप्लेंट विड्रॉ करे, तो वो उसको विड्रॉल की इजाज़त दे देगी अंडर सेक्शन 248. 249 CRPC deals with the stay of proceedings. Suppose the witnesses are not available, are not coming forth, partial evidence is recorded. The court finds that the evidence available on record connects him to some extent. Then it will not resort to 249A by closing the prosecution evidence. it can in its discretion stay the proceedings and make an order of discharge which will not amount to order of acquittal. This is section 249. And 249 is CRPC youngster का तो सबसे favorite section होता है ये, क्योंकि this is a section which is applied for getting an early acquittal without the trial, or trial is in progress and the witnesses are not coming. The court can resort to section 249A CRPC. It empowers the court to acquit the accused at any stage of the trial. And there are two requirements for that. One is if the charge is groundless, or there is no, second is no probability of conviction of the accused. Section 250 CRPC deals with the safeguard to the false, vexatious prosecution or evidence. The court can grant compensation to the accused if after the trial it comes to the conclusion that the proceedings initiated with malafide intent on the basis of false evidence with the purpose of vexation, then it can award the compensation to the accused. Although it is not appropriate at this stage, according to that time, 105,000 rupees can be awarded for under this section by the magistrate first class and 2,500 by the third class. It requires to be enhanced. This is the procedure in the case which are instituted upon the police report. In complaint cases, the procedure is the same. The only distinction is that when the documents under section 241A CRPC are delivered in a state case, in a case which is instituted upon the police report, the complainant will have to file within 3 days of issuance of process. कंप्लेंट का आप सबको आइडिया होगा कि कंप्लेंट फाइल होती है 200 के तहत जब आपकी एफआईआर रजिस्टर नहीं हुई या इन्वेस्टिगेशन जो है वो कंप्लेनेंट के मुताबिक फेयर नहीं हुई, then he would resort to filing a private complaint. Under section 200 CRPC, make statement on oath before, which is called cursory statement. Produce the cursory evidence, the witnesses in support of his claim. He will produce the documents in support of his claim. So the gist of evidence which the complainant has produced in the inquiry under section 202 CRPC conducted by the magistrate in the complaint, and if the process is issued on the basis of that under section 204 CRPC and accused are summoned to face the trial, then the complainant within 3 days of issuance of process will file as many number of copies as there are accused. स्टेट केस में तो था ना कि उन्होंने 161 की स्टेटमेंट देनी थी, 164 की देनी थी और फर्स्ट इंस्पेक्शन नोट की देनी थी. अब जो वक्त बदल रहा है, फोरेंसिक एविडेंस आ रही है, आपने देखा होगा सीसीटीवी कैमरा फुटेज आ जाते हैं, बाकी एविडेंस, तो इसको भी ये लॉ, दिस लॉ रिक्वायर्स अमेंडमेंट के दैट इज टू बी इंक्लूडेड. अभी भी कोर्ट्स दे देती हैं वो एक्यूज्ड अगर उसकी डिमांड करे यूएसबी की या सीसीटीवी फुटेज की, बट इट शुड बी इंक्लूडेड इन द स्टैट्यूट एज वेल.